Hello again, everyone. Welcome to Washington Gun Law TV. I am Washington Gun Law President William Kirk. Thanks for joining us. I am coming to you from our beautiful campus here at Washington State University in beautiful Pullman, Washington. It's Saturday morning. It's eerily quiet around here for some reason, but I'm here because the point I want to make is that here at Washington State University, as well as universities all around the country, innovation is the most critical component of what they're doing. The research and the sciences that go into these universities is what truly sets the American higher educational system apart from all those in the world, and why so many people flock to the United States for higher education. Innovation is critical in all industries. Innovation is critical in our life. But innovation is not permitted in gun control. What, you say? Well, that's actually the truth, and we're going to explain why today. So today, let's spend a few minutes, come to you here from Washington State University, and talk about how there is no such thing as innovative gun control. Okay, so the topic for today's discussion is innovative and cutting-edge gun control, because we see this frequently from those on the gun-grabbing left, that they are coming up with new and innovative and creative ways to save lives. What that is code word for is they are coming up with more and more creative ways to strip you of what is otherwise an inalienable right. Now, as many of you will recall, last summer in the matter of New York Pistol and Rifle Association v. Bruin, a landmark decision was handed down, authored by Justice Clarence Thomas, which specifically talked about the need for historical analogs to support any type of gun control regulation. The holdings of the Bruin court specifically stated, when the Second Amendment's plain text covers an individual's conduct, the Constitution presumptively protects that conduct. The government must then justify its regulation by demonstrating that it is consistent with the nation's historical tradition of firearm regulation. Only then may a court conclude that the individual's conduct falls outside the Second Amendment's unqualified command. Well, since we are here at Washington State University and Holland Library is right back over my left shoulder here, I figured I'd go over and take a look at what the Webster's Dictionary and how they defined innovative. And this is what I found. Innovations is defined as 1. A new idea, method, or device, novelty. 2. The introduction of something new. So it would appear then that if government wants to justify any type of gun control regulation, they need to find a historical analog going all the way back to the time in which we ratified the Second Amendment in order to show that we as a country have traditionally accepted that sort of restrictions. Now, put in more simple terms, there is nothing about innovative and new approaches to gun control laws that's going to have any basis in any history in our nation. What it also tells us, however, is that many of these gun control groups who have been pushing for all new and innovative and radical ideas to strip you of your Second Amendment rights have literally gone out and labeled every single piece of gun control legislation, which is now unconstitutional. Their very own words, which labeled it as innovative, now tells us that there is no historical tradition, there is no historical analog, and these laws must be struck down. Take, for example, red flag laws, or what are sometimes called extreme risk protection orders. Now, those laws didn't exist 20 years ago. Many of those laws didn't exist 15 years ago. No, we've seen an advent of those laws in the last 10 to 12 years. And the groups that have supported this sort of legislation, how have they referred to it? Well, take a look at how Giffords referred to it. Red flag laws are innovative policy solutions designed to save lives. How did Moms Demand Action classify it? Moms Demand Action urges passage of this innovative gun violence prevention bill. But the weaknesses in these innovative gun control ideas are already beginning to show. Consider what the Fifth Circuit did recently in striking down federal legislation which said that people that were subject to civil protection orders must also surrender their firearms. In striking down that portion of federal statute, the Fifth Circuit specifically stated, the distinction between a criminal and civil proceeding is important because criminal proceedings have afforded the accused substantial protections throughout our nation's history. In crafting the Bill of Rights, the founders were plainly attuned to preservation of these protections. It is therefore significant that Section 922G8 works to eliminate the Second Amendment right of individuals subject merely to civil process. And so by that very analogy, The fact that red flag laws are civil in nature and quite innovative, they are clearly in violation of the Second Amendment's command. But it doesn't stop there. Take a look at, for example, San Jose's recent requirement that all gun owners have mandatory liability insurance. So the city of San Jose applauded themselves for what an innovative and cutting-edge measure it was. Take a look at how Shannon Watts from Everytown commented when San Jose was pushing this atrocious piece of legislation. Our grassroots volunteers have been proud to work hand in hand with the mayor, city council, and community partners to help get this innovative package of gun safety laws crafted and across the finish line. This ordinance is an innovative approach to address the costs of gun violence. But the new and apparent weaknesses don't stop there. Take a look at the recent ruling on California's handgun roster and micro-stamping technology. Now, that legislation was signed into law by then Governor Arnold Schwarzenegger and implemented under then Attorney General Kamala Harris. Then Attorney General Kamala Harris said that the technology was readily available, this is 2013, and needed to be implemented immediately in order to save lives. Any firearm which did not have micro-stamping technology since 2013 was not able to be added to California's handgun roster. The only problem is that, like many other things that Kamala Harris talks about, she was dead wrong. There was no micro-stamping technology readily available in 2013, and 10 years later in 2023, the same still exists. It is for that reason that the state of California, even though they're appealing the rest of the ruling, has conceded the point on micro-stamping technology. So, while innovation is applauded in all industries, and why innovation is the key of what happens here at Washington State University as well as universities all around the country, when it comes to your Second Amendment rights, it is not innovation that matters. It is the rich and historical tradition of the text of the Second Amendment. Any piece of gun control legislation which has applauded itself and marketed itself under being cutting edge or innovative has in fact labeled itself as also being unconstitutional. Listen, you may have more questions about this or anything else related to what's left of your Second Amendment rights. If you do, you should know how to contact Washington Gun Law by now. But if you don't, hey, all of that information is in the description box below. In the meantime, I want all of you to remember that part of being a lawful and responsible gun owner, like we talk about all the time here, is to know what the law is in every situation, how it applies to you in any instance that you may find yourself. From Washington State University, thanks for watching and stay safe.